Do you know who the ninth Chief Justice of the United States was? It was Edward Douglas White.
Edward Douglas White was born on November 3, 1845, and raised in Lafourche Parish, Louisiana. He was the son of a judge, a congressman, and a Louisiana governor.
Edward White had a Roman Catholic Jesuit education, and he trained in a New Orleans law office. He went to Mount St. Mary's in Maryland and attended a Jesuit university in New Orleans. He also went to Georgetown in D.C. Edward White was the ninth Chief Justice of the United States. From 1891 to 1893, he was a United States Senator from Louisiana. From 1880 to 1891, he was an attorney in private practice and a sugar plantation owner in New Orleans. From 1879 to 1880, he was an Associate Justice on the Louisiana Supreme Court. From 1874 to 1879, he was a member of the Louisiana State Senate. From 1868 to 1879, he was an attorney in private practice. Edward White was elected a state senator in 1874 for Louisiana. He was appointed by Grover Cleveland to an associate justice in 1878. He was made a U.S. Senate for Louisiana in 1890, and William Howard Taft made him the Chief Justice in 1910, and he finished his term in death in 1921. White served on many cases such as the Standard Oil Company versus the United States and the American Tobacco Company versus the United States. In both cases, he argued that monopolized companies that have a restraint of trade are unreasonable and illegal under the Sherman Act. The Sherman Act aims to prevent inflation created by companies trying to monopolize. It also prevents companies trying to take out any other competitors. His argument failed, however, due to his failure to clearly explain his argument. Some interesting facts about Edward White are that he fought in the Civil War for the Confederate Army. He was captured by the Union Army until the end of the war in 1863. Also, he wrote two important federal emergency powers during World War I, the first being Wilson v. New in 1917, which sustained the Addison Act of 1916 fixing the minimum wages and maximum hours for railroad workers. The second being the military conscription was upheld in the selective draft law case Arbour v. the United States in 1917. Military conscription being another word for draft. Edward White's legacy was the rule of reason used in antitrust cases. It states that companies that are unreasonable or restrain trade are to be stopped by the Supreme Court. He also said that monopolies aren't illegal.
Supreme Court case Marbury v. Madison. John Adams, Thomas Jefferson, John Marshall, William Marbury, and Secretary of State James Madison were all involved. John Adams was a founding father of the United States and became the second president. Thomas Jefferson was also a founding father. He was the author of the Declaration of Independence and became the third president. John Marshall was an American politician who became the fourth and longest Chief Justice of the United States. William Marbury was a successful businessman who was appointed a midnight judge by John Adams. James Madison was a founding father of the United States, became the fourth president, and is called the father of the Constitution. The case happened on March 4, 1801, and the decision was made on January 31, 1803. The case originated in Washington, D.C. In the case, John Adams submits 42 judicial appointments to the Senate. Madison fails to deliver 4 of these commissions. Marbury is one of these commissions, and Thomas Jefferson orders these 4 commissions to be withheld. This leads Marbury to suing James Madison, who was holding the commissions. The case went to the Supreme Court because Supreme Court Justice John Marshall argued that the acts of Congress were in conflict with the Constitution and are not law, and are therefore not binding to the courts, and the judiciary's first responsibility is always to uphold the Constitution. The court case had 2 major impacts on society, and it still affects us today. One of those major impacts was that the case established judicial review, which is the power of the federal courts to declare legislative and executive acts unconstitutional. The court also established Supreme Court as a separate branch of government, making it become the judicial branch. The decision was that the court found Madison refusing to deliver the commission was illegal, but did not force him even with the writ of mandamus in effect. The writ of mandamus was an order from a judge to a government official to fulfill their duties, usually with a petitioner's request. The court instead determined that the Judiciary Act of 1789 was unconstitutional because it purported to extend the court's original jurisdiction beyond that which Article 3, Section 2 established. I personally agree with the court decision as what John Adams was doing was wrong and should not be done by a president. The court needed to find a way around an unlawful act passed by a president, and they handled the situation well.